Good morning, Commissioner, Council, Registrar. I'd like to start off with the land acknowledgement. I'd like to open this hearing by acknowledging that the City of Hamilton is situated upon the traditional territories of the Erie, Neutral, Huron-Wendat, Haudenosaunee, and Mississaugas. This land is covered by the Dish with One Spoon Wampum Belt Covenant, which was an agreement between the Haudenosaunee and Anishinaabe to share and care for the resources around the Great Lakes. We further acknowledge that the land on which Hamilton sits is covered by the Between the Lakes Purchase 1792 between the Crown and the Mississaugas of the Credit First Nation. Many of the council appearing on this hearing today are in Toronto, which is on the traditional land of the Huron-Wendat, the Seneca, and most recently the Mississaugas of the Credit River. Today, this meeting place is still the home to many Indigenous people from across Turtle Island, and I am grateful to have the opportunity to work on this land. And before we get to the matters at hand today, Commissioner, just as a housekeeping matter, I'd like to introduce a document as an exhibit, which document was raised during Ms. Nicole Ottie's examination on October 4th, 2022, but has not yet been marked as an exhibit. It's just inadvertently omitted at that time. The register of the document is HAM 64319. That's again HAM 64319, which is an email exchange between Ron Sabo and Nicole Oddie dated January 17, 2019. I asked them that be marked as the next exhibit, which is number 219.
Noted, Council. Thank you.
Thank you. And Commissioner, we're here today for you to hear motions by the City of Hamilton and Golder Associates seeking leave to file expert reports, responding to those delivered by Commission Counsel. First, Golder seeks leave to file a report by Dr. Hassan Baj, responding to the report of Dr. Gerardo Flinch. Counsel for Golder submitted a letter dated December 7, 2022, setting out the anticipated contents of Dr. Baj's report and the relevance to the inquiry's terms of reference. The City of Hamilton seeks leave to file two reports, one by Mr. David Hine, responding to the report of Dr. Flinch, and one by Mr. Dewan Kareem, responding to the report of Russell Brownlee. Counsel for the city also submitted a letter dated December 7, 2022, setting out the anticipated contents of the reports of Mr. Hine and Mr. Kareem and the relevance to the inquiry's terms of relevance. And the letters from Counsel for Golder and the city, respectively, have been posted on the inquiry's website. And on Friday, December 9th, you directed that Counsel for Golder was to proceed first, and the City Counsel for the city second. And so I would ask Ms. Roberts for Golder to proceed.
Thank you, Commissioner, Counsel. Golder seeks leave to submit an expert report from Dr. Hassan Baj of the University of Waterloo. Dr. Baj is a tenured professor and the chair in sustainable pavement engineering and civil and environmental engineering at the University of Waterloo. He's a doctorate in civil engineering from the National Institute of Applied Sciences of Lyon and a Bachelor of Civil Engineering from the University of Damascus. I don't intend to go through his CV, but he has extensive experience in materials engineering and particular focus on asphalt. In his report of November 2022, Dr. Flinch develops detail on the outline he provided in his primer at the very outset of this inquiry. And my client Golder is largely in agreement with the findings and observations of Dr. Flinch. My focus is on a particular area of Dr. Flinch's November report. In his primer, Dr. Flinch describes the characteristics of pavement surface that affect friction. He describes the two main components that affect the tire pavement friction of microtexture and macrotexture. And really, we're focusing here on microtexture. Microtexture is the fine scale texture on the surface of an aggregate. And how it interacts with the tire. Microtexture is primarily affected by the aggregate and its surface aggregates and its polishing characteristics. In broad strokes, the more resistance to polishing, the better the frictional properties of an aggregate will be able to provide, in particular, whether it will be able to provide good and enduring frictional characteristics. Now, you'll remember at the outset of this hearing, we went through the evidence in relation to the design and construction of the Red Hill Valley Parkway. And part of that evidence was that Dufferin proposed to supply aggregate from a quarry in Quebec, the Varennes quarry. And that aggregate was to be used both in the stone mastic asphalt surface on the main line, as well as the ST2 asphalt for the ramps. And although that aggregate from the Varennes quarry had been used in Quebec, it had no history of use in Ontario and was not on the designated source materials list in Ontario. So in 2002, there was an extensive process of the qualification of that aggregate. And the first phase of the hearing in June of this year went into that qualification, both in terms of the laboratory testing results that were provided, as well as what testing had been conducted to assess its polishability. And as part of the data provided to qualify the aggregate as suitable for use on the Red Hill Valley Parkway, Dufferin provided a number of laboratory tests. Chief amongst these that I want to focus on is the Micro Duval abrasion and Los Angeles abrasion tests, as well as a test used in Quebec to measure the resistance to polishability, which was the coefficient of polishing by projection test, which I'll call the CPP test. So in Ontario, the test that the MTO uses to assess polishability of an aggregate is the polished stone value test, and there's been significant evidence on that. In Quebec, they use a different test to assess the same thing, which is whether the aggregate is susceptible to polishing. And we understand that the CPP test to be an equivalent methodology. In his November 2022 report, Dr. Flinch focuses on one particular test assessing the polishability of the aggregate, which is the PSV testing. But as I said, this is just one of the tests that were provided by, this is just one of the tests that would assess polishability. And Dr. Flinch does not, in his November report, consider the other testing results provided by Dufferin, which are relevant to the assessment of resistance to polishing. Specifically, Dr. Flinch does not consider the results from the Micro Duval and LA abrasion testing, and he does not consider the results of the CPP testing. So the essence of my submission here is that Dr. Flinch hasn't considered all of the evidence, and that the totality of the evidence is important in evaluating the aggregate. We propose that Dr. Hassan Baj of the University of Waterloo will assess these additional tests and augment the evidence provided by Dr. Flinch. Dr. Hassan has worked for Lafarge and has significant experience in materials engineering and is well qualified to provide that analysis of the laboratory as well as the CPP test results. We anticipate that Dr. Baj's evidence will address all of the testing conducted on the Varennes quarry aggregate, indicating its quality and resistance to polishing, and that this will supplement Dr. Flinch's findings. The testing conducted on the aggregate in 2007 is, we submit, important to the assessment of the quality of the aggregate.
If what you're saying is the testing of Dr. Baj is the report of Dr. Baj is really limited to conducting an equivalent analysis in respect of these 3 additional tests to that of Dr. Flinch in respect of the PSV test, that would seem to be relatively straightforward and not involve any particular additional evidence. Is that correct?
That is correct. He's going to look at the evidence that already is in the record.
It is already in the record.
That's correct.
And not beyond.
Not beyond. He will, I'm confident, identify additional academic analysis that casts light on the testing. But if you're asking specifically about whether there's additional evidence that will be introduced, the answer is no.
With respect to the aggregate, no.
Correct.
Simply with respect to the meaning or understanding scientific basis of these tests.
Yes, that's right.
Ms. Roberts.
Thank you. I think that's important, but it goes to a point that I just want to highlight here, and that is, I think that an assessment of all of that evidence that was brought forward by Dufferin and reviewed by Golder and others in 2007 is an important part of this assessment, and really goes to an overview of what was done at the time, and whether the testing that was done provided a realistic and thorough assessment of the likelihood that this aggregate would provide good and enduring resistance to polishability.
Mm-hmm.
And again, and part of that is, and I think that I'm going to go back to this theme, but I think that this deserves particular scrutiny, because one of the issues that's been a persistent theme is this notion of whether this aggregate didn't provide the qualities that it should have.
Mm-hmm.
And I think that it's an important exercise to undertake and scrutinize with some focus, is whether any of the test data in 2007 indicated that the aggregate was likely susceptible to undue polishing.
Mm-hmm.
And then I want to turn then to some other aspects of Dr. Flinch's findings.
Mm-hmm. So that is essentially prospective.
Yes.
Looking at the testing in 2007.
Yes.
Whether it adequately addressed the likely future performance of the aggregate.
Right. That's exactly what I'm looking at. So whether all of that work that was done in 2007, part of that is whether that was a sufficient survey. And so Dr. Baj is going to look at that. And then, in fairness to the work that was done in 2007, whether there was anything there that could have been a flag to say, no, this aggregate might not have been resistant to polishing, whether there was a flag there. Okay, I want now to turn sort of to a different part of Dr. Flinch's assessment, and really what I'm scrutinizing here is his findings in his report in paragraphs 2.1.5 about polished stone value, because he looks at the PSV testing that was done, and PSV testing was done on the Varennes aggregate in 1992. And then again in 2008. It was tested also in 2017 by Golder, but that was by taking cores of the aggregate that had been in service and for 10 years in the Red Hill Valley Parkway. And Dr. Flinch in particular focuses on the data from the testing conducted in 2017 of the recovered asphalt, recovered aggregate. And what he states is that the PSV testing in 2017 resulted in a test result of 45. And he describes that as relatively low compared to British standards, which he refers to. And he goes on to say that this indicates that the aggregate is susceptible to polishing. PSV would, and the issue we have here is that PSV is typically conducted on virgin aggregate. And the question is whether an apples and apples comparison can be made to test results from virgin aggregate as opposed to the in-service aggregate. We're anticipating that Dr. Bosch, who's not yet provided an analysis on this topic, but we anticipate that he will not agree that such a comparison can be made. In other words, what in-service testing results doesn't tell you what you would have found in 2007. And in particular,
yeah, sorry, and that's the point I want to stop at. The issue about, there can be two issues. One is, what does that testing say about the aggregate in 2007? The other is, what does it say about the aggregate in 2017?
Yeah.
I want to focus on the latter for a second. Obviously, you're not challenging the actual test result of 45.
That would be awkward since it's my client's test.
Exactly. and are you your client's evidence, as I understand it, is aligned with Dr. Flinch's in a prospective sense that 45 is too low for any new laying down of asphalt, and that if this was, of course, proceeded in the context of hot in place, but if hot in place asphalt or resurfacing was contemplated, then you would have to build up the quality by introducing much higher performing aggregate to balance out the existing aggregate at having the PSV value of 45.
That's correct.
Yes. Right. And that seems to be consistent with, I say only seems to be consistent because we haven't had that conversation, but on first blush seems to be consistent with Dr. Flinch's view that as of 2017, the aggregate in place could be demonstrating low micro friction.
Yeah, so I think Dr. Flinch says his language is relatively low. I think Dr. Uzorowski said that value was moderate, but you're both you're absolutely correct. The outcome of that analysis was that Dr. Uzorowski did not think that the aggregate from in-service that had been in service on the Red Hill Valley Parkway could be used without augment as a new surface.
Right. And Dr. Flinch's report goes a little further and suggests that to the extent there were friction problems on the highway at that time that are attributable to the asphalt, that would be attributable to the state of polishing of the aggregate.
Yes.
And I don't think your client is taking exception to that. Is that correct? Your client is really taking exception to the use of the testing results in 2017 as an indication of what the aggregate quality might in fact have been back in 2007, notwithstanding the testing that we've just addressed.
That's correct.
Is that correct?
That's absolutely correct. And the other thing that, and the other part of this is is that Dr. Flinch seems to use that 2017 testing as an indicator of a decline in friction on the asphalt. He says that, and perhaps maybe jumping forward too quickly here, but one of the issues in Dr. Flinch's, one of the findings he makes is essentially a correlation here, or a connection between what he describes as the relatively low PSV of 45 obtained from the in-service aggregate. And he says that that's consistent with the significant drop in friction of approximately 20% observed between 2008 and 2014. And he notes that an aggregate susceptible to polishing loses its microtexture because of the abrasive effect of traffic. And so what he seems to be doing is suggesting a relationship between the, as he said, relatively low PSV in 2017 as reflective of a decline in friction on the Red Hill between 2008 and 2014. And I think that that's a really interesting question, whether in fact that 2017 is evidence of polishing. And when I raised that as a flag with the materials experts that I consult, including Dr. Baj, they're doubtful, but they are also not aware of research. So when Dr. Flinch raises this as a connection, some sort of a correlation, I say that deserves some scrutiny. If you're going to say that this shows and reflects polishing, let's shine some light on that and see whether that's supported by academic research. So I am anticipating that Dr. Baj will look at that, and I have not been able to offer a potential opinion because I don't know what that might be, and neither does he right now.
That would seem to cross over into the second category.
Yes.
Everything else seems to be in the first category. In other words, if I can put it in a different way, your client's position would be that this would that most of the report would support the conclusion that whatever the actual experience of this aggregate, there was no reason to believe that it would not have performed adequately.
Correct. And in this part of Dr. Flinch's findings, though, seem to focus, just as you've identified, on the second part is what actually happened.
Yes. And what was the state of there's no real issue about what the actual state is, but you're in the second part taking some exception to the suggestion, potentially to the suggestion that there was actual degradation of the aggregate.
Well, I mean, I can hear my client's voice in my ear saying all aggregate polishes. So.
Yes, well, that's where I'm that's where I'm having trouble. But it doesn't seem to me that this is the point at which we have to discuss that we have to decide that. I'm simply trying to elucidate the issues that are being raised by the report.
Exactly so, sir. But I think but I think that Dr. Flinch raises a really interesting potential theory. I just think that the statement can't be left as it is and deserves further focus. You know, having said it, that it needs to be looked at.
Okay, let me just make some notes if you don't mind. Okay, I've tried to capture what we've been talking about in the following. I've said most of the report is intended to deal with whether the testing in 2007 can be used to contradict the evidence that the testing done in whether the testing in 2017 can be used to contradict the evidence that the testing done in 2007 was sufficient to conclude there was no reason to doubt the future performance of the aggregate. The state of the aggregate in 2017 is not challenged, or the fact that it would be a source of low friction via low microtexture. However, there is some doubt about Flinch's suggestion that the aggregate PSV declined, or testing results declined in line with the observed decline in the friction numbers as tested by the MTO.
Thank you, Commissioner.
Is that an adequate representation of what we're talking about?
Yes, I think it's you've captured it perfectly. I realize that in jumping ahead to that last question of the 2017 testing, I jumped over one of the points which you've covered in your summary, which is whether the comparison of the 2017 and the use of that testing in compared to what was found on the PSV testing in 1992 indicates a seam or a consistent, something about the way the rock was quarried out of the Varennes
Yeah.
quarry. I think you've captured it with what you've got, but that's something that I'm anticipating Dr. Baj is going to say, having significant experience working with aggregates with Lafarge, he's going to say, no, that can't be used, that testing cannot be interpreted in that way. And it's not in fact likely that the steam in 1992 is reflective of what was found from aggregate excavated in 2007.
The last point, and I just raise it because I guess it will be an issue that someone will have to address. It still leaves the question about how we get from what was observed in 2007 and what was observed in 2017.
Sorry,
we're still left with the question of, was there not a decline in the quality of the aggregate between 2007 and 2017? But perhaps that's picked up by the suggestion that the testing can't be compared.
Right? I think that's right.
Testing, okay.
Right. And if you want to look at the quality of the aggregate as a resistance to polishing in 2007, that the correct test to be looking at is the CPP test, not trying to speculate as to what 1992 might have shown you or what 2017 of the
actually
showed.
Okay, that's fine. Thank you. I don't have any other questions.
Okay, thank you. Then that's what I'm anticipating Dr. Baj will address, and I submit that the importance of that testimony in relation to the establishing the aggregate was resistant to polishing and would provide good frictional properties is important to the terms of reference.
Okay, thank you. I'm going to reserve comment until the end of the submissions today. Just before we proceed, I think I'm going to need another pen. So if you bear with me for a second, I'm going to get one on the desk. Okay.
Ready to go?
Yes.
And now, Mr. John Chen, counsel for the City of Hamilton, as I said, has submissions for the City of Hamilton and two responding reports that the city is seeking to have leave to file. Thank you.
Mr. Chen.
Thank you, Mr. Commissioner and Commission Council. So as we've set out in our written materials, the city is seeking leave to put forward evidence from two experts, David Hine on the friction-related topics and Dewan Kareem on the road safety and design aspects. You have their CVs, Mr. Commissioner, but both Mr. Hine and Mr. Kareem have significant expertise in their fields. Their expertise, as I understand it, is not in dispute. Just very briefly, Mr. Kareem is the practice lead of the transportation engineering and safety group at 30 Forensics, and he specializes in transportation engineering, plan and traffic safety issues, and he has over 2 decades of experience in this area. Mr. Hine is a principal engineer at Applied Research Associates, and his expertise includes pavement design, evaluation, pavement construction materials, and he's has actual experience of friction testing and analysis on various highways, including the 407, York region. In that case, it's very intersections. He's working on rehabilitation projects as well. I would just say that Mr. Hine is He would be the only Canadian-based friction expert to testify more broadly in this inquiry. Of course, you just heard from Ms. Roberts and Professor Baj will be speaking on a more limited issue. So both Dr. Flinch and Mr. Brownlee address a number of topics in their reports, spans 30 pages or so. The city appreciates that this is not your typical litigation responding report. And to that end, Mr. Hine and Mr. Cream come at this with a focused approach. And I appreciate that they touch on a number of topics, but at the end of the day, we say it's on particular issues in that regard. So the city's view is that leave should be granted because Mr. Hine and Mr. Cream will, one, on certain issues, be providing a contemporary perspective from those raised by Dr. Flinch and Mr. Brownlee, and two, they'll also be opining on issues that are unaddressed by those two experts. And so we say, in our view, each of those criteria should be sufficient for leave to be granted so that the inquiry can proceed on fulsome evidence. This approach, we say, would be consistent with the rules of procedure for this inquiry, which is focused on evidence that is helpful to fulfilling the mandate of the inquiry. And I'm simply referring here to Rule 3, which is the general principles for the receipt of evidence and testimony of witnesses. What falls into the helpful category is broad. And again, taking guidance from the rules, the experts would be witnesses that are holding a contrary view, as I mentioned, or challenging a view, or commenting or supplementing a particular point. One of the great strengths of an inquiry process is the ability for you, Mr. Commissioner, to hear multiple and differing viewpoints. And this strength is emphasized in a case where we are dealing with not just a single, but a plethora of technical concepts that are not well established and deserve to be debated. Of course, at the forefront is the analysis of roadway fiction, but even that, I think, as we just heard from Ms. Roberts, can devolve into a number of other technical related questions. Road safety and design are not any simpler. But beyond the responses that Mr. Hine and Mr. Cream will make, there is a further reason that we would ask you to bear in mind, which we flagged in our written material. Of course, outside of this inquiry, there are a number of other active legal proceedings respecting the Red Hill Valley Parkway. And as part of this inquiry, we of course expect that you will make numerous findings as it relates to the terms of reference. Those findings, although made in this context, may have influence in those other legal proceedings. Obviously, I can't say for sure that will happen, but as a lawyer, I think that's something we can predict with reasonable confidence. So for that reason, again, being open to hearing different viewpoints and receiving a balanced response, especially on technical issues, which is where there may most be a desire to rely on elsewhere, is important in our view. And just as a final opening point, the city appreciates that there are competing interests at play and that the commission is not looking for duplicative evidence and would like the expert phase to be efficient. This is top of mind for us. And as I say, Mr. Hine and Mr. Cream will be efficient in providing pointed responses. We expect that these pointed responses will be insightful and helpful, and we'll get into the issues that we've raised, and we don't expect them to add significantly to any schedule. I think they've been allotted about 2 days or less. So in our view, there's lots to be gained there. So just with those opening remarks, what I propose to do is go through the categories and the materials that we have filed and explain its significance.
Sure. Just before we begin, can I raise one question in respect of the three reasons, three general reasons that you raise in your covering letter.
Yes.
Item 1 seems to suggest that the terms of reference include finding whether or not the collisions on the R8 on the Red Hill Valley Parkway are higher than on other roadways with similar characteristics. I'm not aware of any provision in the terms of reference that require such a finding.
So in our view, that particular point is particularly important because it deals with the terms of reference that address whether there's any misconduct or negligence in failing to disclose the report and its recommendations. And it goes to the impact, as I say, of not disclosing the report. The comment about high wet road collisions is often assessed in totality with the other evidence, such as the friction level, to understand what, if any, countermeasures should be implemented. So when we consider the effects of not disclosing the report, we say there's a corresponding question of, well, what information was known, true, and relevant. And so to us, a key point would be whether, in fact, the Red Hill Valley Parkway had an overrepresentation of collisions, including wet road collisions. We've heard an abundance of evidence, not only from the fact witnesses being asked about wet road collisions, but also the experts such as Dr. Flinch includes as part of his conclusion that drives his conclusion that there is I think the wording is something to the effect of a very high proportion of wet road collisions. So by looking into this particular point and doing it properly, because we say that it hasn't been properly, and we can talk about Brian Malone's evidence to that effect, where he makes the comparison to provincial averages, but it acknowledges that that's not an apples to apples comparison, because what you need to look at is comparison.
Let's just stop for a second. There are two very different issues. The proportion of wet weather accidents on the highway and that came to be assessed at particular locations. And then the much more general question of collisions on the Red Hill Valley being higher than other roadways. This refers to the latter, and I don't see how that is within the terms of reference.
So the analysis will be segmented and obviously this will be the I hope I'm doing justice to the expert. It'll be segmented, and so there will be an overall comparison, and as it relates to ramps or the wet road areas, I understand that there will be a comparison based on proxies.
Well,
so it's going to be, as I understand it, a apples to apples comparison.
Let's proceed through these. I wanted to understand what the thinking was, because I'm not at all convinced at the present time that the terms of reference require that I make any finding with respect to whether the collisions, and I'm talking now collisions on the highway, the expressway, are higher than other roadways with similar characteristics. So beyond what we have in front of us, but let's proceed with.
Okay. If I could just clarify that you use the term roadways, it would be, of course, a highway to highway.
I didn't use the term roadways. You used the term roadways.
I apologize for that if I did.
Okay,
So,
well, why don't you proceed through what you want to say with respect to Mr. Hines' report?
So 1A, if we go to Appendix A of our written material, characterization of friction levels, We've titled this the characterization of friction levels. And so in his report, Dr. Flinch goes through the friction data from the locked wheel to the grip tester measurements. And in numerous places, Dr. Flinch concludes that the friction results are relatively low. So Mr. Hine will provide a contributory review here. He doesn't accept Dr. Flinch's conclusion that the results are relatively low, and his anticipated view is that the friction results are reasonable based on.
And I can help you out a little bit on this one. This seems to me to be an example of a category that should be relatively straightforward. As I understand it, there would be no new evidence adduced. This would simply be his opinion based on the evidence that is already before the commission. Is that correct?
Yeah, that's correct. He won't be bringing comparator friction results.
Right. And I would understand that to be the same with respect to B.
With respect to B, that's correct. Obviously, with the caveat that he may be referring to any studies or papers that he is aware of. Just especially with respect to the friction value conversion, I think he has a view on that and the availability of papers to support his position.
Let me just make some notes here. And I would say this, correct me if I'm wrong, but I would assume the same is true with C.
The same is true with C. That's right. Again, with the caveat that he may include reference to papers or studies and whatnot.
Right. In the same way as Mr. or Dr. Baj might refer to the scientific basis for his opinion.
Correct. Yeah.
Okay.
So that takes us to D.
Right.
Which is the applicability of the UK
So
investigation.
my question here is, to what extent is he intending to provide additional fact evidence?
So my understanding is just this, set up the position. His view is that the guidelines are developed under different criteria. So to the extent that him referring to studies and how the UK guidelines are developed and in what conditions and whether they can be applied to the Canadian context, I think that would be the extent of the research or discussion that he would be providing. It's a point that Dr. Flinch kind of urges the application of the UK guidelines, but there's on our read and Mr. Hines' read, little substantive discussion on why we should be applying the UK guidelines and whether they can be appropriately applied.
Well, it's one thing to give an opinion as to whether they can be appropriately applied. It's another to provide a whole lot of new evidence that might have been adduced a long time ago.
So Mr. Hine will come at it with his broad experience and expertise with respect to the standards he has seen.
His experience is in Canada, correct?
His experience is in Canada, but beyond that as well, he's worked in the U.S. as an example.
Well, but that's not the UK. I'm trying to understand how he is going to be able to adduce any new factual evidence, and indeed why he should be allowed to introduce, as opposed to providing his opinion that for these conceptual reasons he doesn't believe it should be relied upon.
Right, and perhaps we may be saying the same thing, and I'm perhaps misunderstanding the question.
Well, we're going to end up having to say the same thing. So let's,
I appreciate that. I appreciate that. But I think the majority of his analysis will be based on the differences, which frankly he's cited to me without reference to the papers. It's, you know, one of the comments that Commissioner Council had raised to us is whether there's a potential that he will be relying on new evidence, and I frankly took that to mean papers as well, and I was just that was my additional input. He is going to focus on his experience and why the guideline is different, and he'll put forward the red flags that should be considered before, so that you have that to consider on the question of the applicability of the UK guidelines. I'm content, though, that we are saying the same thing, Mr. Commissioner.
in other words, no new factual evidence.
No new factual evidence.
His comments or opinion based on his personal experience.
Understood.
Okay. Let's turn to E. What is contemplated by E?
So, Dr.
I'm sure the MTO would be pleased to know that he regards their use of FN30 as reasonable, but I'm not sure that anyone is objecting to it.
So we think there's value.
But what exactly is contemplated by this?
So Mr. Hines' anticipated evidence will be the FN30 guideline is a reasonable one to apply to municipalities. That it's a conservative threshold suitable for municipalities, and he will base that opinion on his previous experience. Now we have Dr. Flinch, who, although goes through an extensive analysis of friction, he explicitly avoids, opining on the application of the FN30 guideline. But we also know that the FN30 guideline is really the only local or Ontario-based guideline that we have. And we think there's value in at least having the Canadian friction expert speak to the FN30 threshold and whether that is one that should apply to the city of Hamilton.
Okay. Again, that's without any new factual evidence, simply his views with respect to that. Is that correct? He's not actually acted. He's not been a member of the or an MTO employee. Is that correct?
Yeah, I don't believe he's been an MTO employee. I guess that's the problem with having an extensive resume.
Right.
I can confirm that, but my instinct is that he has not been employed. It's not to say he hasn't provided some services as a consultant throughout the years.
I guess my reaction is, if he wants to say it's a reasonable number, it may not be objectionable, but it's not really going to have any influence because of two things. One, the MTO's evidence was a little bit more refined. It was up and down depending upon the circumstances in which one was analyzing matters. secondly, whether it is or is not a reasonable standard is ultimately, if there is such a thing, a scientific question, not a question of practice. There's no suggestion that the practice is improper. There's no suggestion at the present time that there's any issue with any scientific basis of 30. In fact, there is no scientific 30 basis. It's a rough and ready guide. So with those qualifications, what exactly is Mr. Hine going to add?
Well, I mean, with respect, I appreciate the MTO's evidence was refined, but at the end of the day, it wasn't expert evidence from someone who has, worked in the
No, but
field.
how is his expert evidence? Where is the expertise as opposed to experience? Well, he's observed something, but where's the expertise in this evidence?
So
Where's the scientific basis for something he's going to say?
no, and I understand your point on that. And our discussions with him specifically on this point haven't been as refined as I think the questions you're asking me in the limited time. But when he talks about the conservative threat, as I mentioned, he thinks that it's a conservative threshold suitable for municipalities. He can draw on his experience as to what other jurisdictions I think he has seen and can make a comment on that.
You see, that seems to me to be more in the nature of new evidence, of a factual nature.
And I don't think I completely agree with that. I do think in the Brownlee reports and the Flinch report, there is some new material in there, and I would
What's
ask
the new material? What you just described, I'll repeat your words, was he can describe what he has seen done by other municipalities. That doesn't strike me as anything more than factual evidence. But incidentally, that seems to relate to the next category of question, not to this category of question, which is about the MTO's use of FN30.
Correct. That's correct. And I mean, the majority of the discussion in this section by Mr. Hine will be, as I say, that the guideline is a reasonable one for municipalities to apply. And again, that is a perspective from an expert that I think we do not have on the record and would benefit from, so that we have a well-rounded discussion.
So this is really, your issue is not so much E as in F.
E as in?
But rather F. That the standard of FN30 is a reasonable one for municipalities.
Sorry, Mr.
Isn't F the?
Yeah, so it ends at E. Are you referring to?
Right. Oh, I'm sorry. No, there's no F. It's number 2.
Oh, right.
E is I apologize. I was just assuming if I flipped the page, I would find it under F. E is just a lead up to number 2.
Yeah, I agree that they are related. I would agree that they are related, yes.
So I'm not sure that you've yet identified why E is useful, or indeed why E is expertised. That's dealing with the MTO's use of FN3.
Perhaps it's just a word choice of mine, but it's the municipalities, the application of the MTO's 30FN to municipalities. That's what that heading is meant to convey. But both E and 2, in my submission, falls under the category of, Mr. Hine is the only Ontario-based expert that has this expertise and can provide a unique perspective based on his experience.
Okay, so you're saying E is supposed to be the use by municipalities of FN30.
Correct. 2 is a bit more general, just in the sense of friction management programs and whether those existed in Canada, in Ontario.
Well, so let's just deal for a second with F.
2?
No, I'm sorry, E.
Okay.
Yeah, E, not F. E, why, in the context of this inquiry, where there was no friction management program, would it be helpful to the inquiry to be told that FN30 is a useful standard for municipalities that have a friction management program?
So
Are you thinking that the inquiry should recommend that municipalities have a friction management program?
no, I'm not going that far. The point about the 30FN is to provide a framework under which we can assess the friction test results that were obtained, and from that draw various conclusions as to, of course, with other evidence as to the safety of the roadway, whether investigations are needed, countermeasures, and so on. That's the intent of E, so that there's something to measure the friction results against. And to keep in mind that Dr. Flinch it's unclear what his views are about the 30FN, but to us, he seems to be pushing the UK guidelines, and for you to measure the friction test results based on the UK guidelines. And so all the simple point we're making is that the 30FN is the guideline or threshold that we should be looking at, because it's the one that was developed here. And going back to the other point about whether the UK guidelines are applicable, Dr. Hine will raise the red flags so that you can consider, when you're trying to balance, assuming you have to go through that analysis, when you're trying to balance between, well, how should I look at these numbers? Is it the MTO's 30FN? Is it the UK guidelines? It just strikes me that if we don't have a guideline that we can say we go on, then the numbers, the friction numbers, have little meaning in about.
Well, so, but I'm now confused. Um, Obviously, in assessing friction or the traffic safety generally, the city never had the MTO numbers.
Right.
So all they had was the trade wind report. And Dr. Flinch's evidence is that they shouldn't have ignored it. I'm oversimplifying, I appreciate, but that and for much of the terms of reference, that's all we have. Now, what's the context in which you think that it is useful for the inquiry to be told that the MTO numbers are credible and should be preferred to those of the trade wind report? I think that's where you're headed.
Yeah, no, and that is where we're headed. Of course, there's the reference to the 2007 that there was knowledge of.
Yeah, but that's not really relevant for that. That's got to do with a different problem altogether.
We still see that as a data set that's
fine.
prepared, and I think
believe me, that's not going to be determinative. So deal with the bigger question.
Fair enough.
What's the context in which apparently you want the inquiry to disregard the trade wind report and prefer the MTO results? I'll stop there.
Well, the trade wind report obviously references the grip tester numbers, and by accepting the MTO's 30FN, I think it puts the grip tester trade wind numbers in context, which is always that, how do we understand these numbers and what do they mean?
Oh, I'm asking what's the context in the sense of what are the questions under the terms of reference that the inquiry has to address, where you say the inquiry is going to be urged to disregard the trade wind report and consider the MTO numbers are somehow determinative?
I think a number of the terms of reference go to that point. The ones that talk about what's the impact of not disclosing the report and whether that would have led to, or whether that contributed to accidents, whether that contributed to, whether that would have led to other road safety changes. And just, I should be clear that we're not asking you to completely disregard the UP guidelines. It's more of a, Dr. Heim will, as I said before, put the red flags up, but it's also to look at it from the lens of the 30 FN. I think both of those thresholds and what they mean address a number of these terms of reference that, whether the users of the Red Hill were put at risk as a result of failing to disclose the report, because we need the standard to understand the friction numbers and what they're suggesting.
I'm not sure that I fully understand then what E is all about, but
perhaps there's something I can clarify to assist with that point. Dr. Flinch, I think, the stepping back, Dr. Flinch puts forward the UPAID guidelines and says we should look at the numbers through that lens. We say we should look at it through the MTO's FN 30. Dr. Flinch does not offer an opinion on why we should use the FN 30. Mr. Hine comes in and does exactly that. And so, frankly, whichever whatever purpose the UK guideline discussion goes to in the terms of reference, we say that discussion on the FN 30 point would go to the same terms of reference. It's just a matter of which road you go down or which standard you follow.
Okay, I mean, I think there's a certain air of unreality to this, or a level of generality, which I think really misses the evidence, which is that from 2013 to 2018, there was a terrific evolution, as according to the evidence, in terms of what the traffic safety consultants, I guess SEMA, and the staff themselves came to concentrate on. And these aggregate numbers really ceased to have any significance, as the concentration came to be about certain locations, northbound and southbound, under certain environmental conditions. So, speaking for myself, I think the evidence of the MTO that's most useful and nuanced is about how they looked at accident locations and how they factored friction in as one of a number of matters. But if the exercise here is simply, again, to provide an opinion without any additional factual evidence, an opinion that FN 30 is a reasonable standard, I suppose it's innocuous.
So I think the analysis is one that takes into account a number of factors, and I appreciate the point you've made about friction being one aspect of the analysis, and of course the wet road collision is another one. That said, there needs to be some foundation set, and obviously the MTO has done a lot of that, and I have to go back to the point of Dr. Hine being the only one who can provide the expert evidence on that point.
Okay. Well, let's turn to the more difficult one in number 2.
Should the friction management programs?
Right. So the evidence before the inquiry right now is that no municipality in Ontario has a friction management program.
I think that's correct, and it's come out in, for example, the agreement between council. I certainly don't think it's well developed. I did go back.
I think the evidence. I'm not sure how you can develop a negative. The evidence of Mr. McGuire was that he attempted to ascertain whether any municipality had a friction management program. he had conversations with a counterpart or someone in Ottawa, was told they did not. Mr. Moore was very emphatic, I believe, that there was no friction management programs in any Ontario municipality. So what exactly is this intended to speak to?
So of course, one of the distinguishing features is that Mr. Hine is an expert and he can provide the expert perspective, and he's obviously broad expertise, decades of experience, worked with many municipalities. So he will speak to.
I think you're treading water. What?
And just to be a bit more nuanced on the point, though, he will speak to Ontario municipalities not having friction management programs, but also, as I understand it from him, why that is the case.
Okay,
And
he's
so
not an expert. This is not a matter in which he's an expert. At best, this is his view based on his experience, whatever it may have been with municipalities over the years.
Yeah, I think though his experience can be categorized as specialized experience in the sense that he's done this for decades and has a nuanced appreciation, much more than I think some of the fact witnesses.
What is he going to say?
So the trouble, and just be upfront on that, is that the report is not complete, and I can't summarize what his position is, and of course he's a bit hesitant to provide all the details, having not done the work in
Mr.
time
Chen,
available.
if your client had wanted to provide this evidence, they had 3.5 years to provide it, including their own participants. If this is evidence that you think is important, I think it would be much more appropriate for representatives of municipalities who are actually knowledgeable in terms of their own experience to come in and to provide that in some way or other. In other words, to work up a proposal that gets this evidence in a more balanced way than what you're proposing, which is inevitably dependent entirely upon his experience at certain times in certain places.
So our understanding was that this sort of evidence from Dr. Hines should be left until the expert phase to deal with.
Well, I'm not suggesting if you feel that it's important evidence, it may be that there's a proposal that can be worked out with Commission Council that involves getting the actual knowledgeable parties of the municipalities to provide that evidence. But I don't think Mr. Hine is an expert in this. He's never worked for municipality. It's entirely it's episodic.
I just want to ensure that we are giving credence to Mr. Hines' expertise as it relates to friction and his involvement with municipalities. I wasn't aware that his expertise would be in dispute, and if there's any way we can have an opportunity to flesh that point out and draw out more experiences, I think that would be helpful for the commission to have. But it's not merely fact evidence. We say it's expert evidence, and just on the point that it's not fully developed. Of course, we come at this as as a leave motion, not needing to have fully developed a report, which may ultimately not be granted.
I fully understand their limitations. You haven't done the report, but I think if this evidence is appropriate, it may be necessary to consider another route by which it is, or another means by which the evidence is adduced. But we'll leave it at that for the moment.
Okay, thank you, Commissioner.
Okay, number 3. This may duplicate something of what Golder is doing. Is that right?
That's correct, Mr. Commissioner. It's about aggregate quality, which you had an extensive discussion with Ms. Roberts. So Dr. Flinch draws various conclusions about the aggregate quality and frictional values based on the polished stone values obtained in 2017 on the Red Hill. In particular, Dr. Flinch makes a connection between the 27 PSV testing and the frictional decline, which again you again discussed, and we agree with Ms. Roberts that it's a really interesting question without an answer. And so Mr. Hines' focus is going to be, I think, what we categorize the second part of Ms. Roberts' analysis. Yeah. I think her first part is focused on all the existing testing that was already done and what that shows with respect to the polishing qualities. And we're happy to leave that to Professor Baj. And as you know, Ms. Roberts was talking, I was trying to think about a way we can streamline this a little bit to avoid duplication. So the beauty of an inquiry is that we can be creative about certain things. So if there's collaboration to be had, so that there's either a panel or a sole voice, so be it. But that is the point there.
Okay. Just in the interest of time, as well as everyone's cost, it would seem that if the point that Dr. Baj is addressing is the same as the point that Mr. Hine would be addressing, it wouldn't be any need for Dr. Hine's evidence, especially as, well, I won't say that. But two people saying the same thing is not going to have any more.
Yeah, I mean, to the extent that they are going to be analyzing it the same way, what they may come to the same conclusion for different reasons. But as I say that, I will make one distinction, which is Ms. Roberts pointed out that it would be awkward for her to dispute her own client's findings on the PSV of 45 in 2017. My understanding is that Mr. Hine takes a different view and would like to look into whether PSV testing on an aggregate that's been in service for 10 years is a reliable way of conducting the test. As I understand it, his knowledge is what the PSV testing is that it's typically done on virgin aggregates.
Okay.
Ms. Roberts has jumped on.
Oh, and I don't mean to intrude, but it just occurs to me that there's an opportunity to have a dialogue with council on this to make sure that we're efficient, and I will make sure we do that.
Thank you.
Thank you.
Okay, so that takes us to number 4.
Right, so number 4, countermeasures. Dr. Flinch, jumping to the point, concludes that resurfacing or microsurfacing is a treatment that could have resulted from a detailed safety analysis. So Mr. Hine will provide a differing view on what countermeasures he believed was necessary to be implemented based on the available information. And you'll see in Mr. Hine's resume that he has significant expertise on pavement management and rehabilitation throughout his career in Ontario, so we can offer a unique perspective in that on that front. And his anticipated opinion will discuss the factors that are considered before implementing a particular countermeasure. He's I think had previous engagements about that. And in respect of the 2014, his anticipated opinion is that it was not unreasonable for the city to focus on other countermeasures. And
Yeah,
of course,
and that's fair. I mean, that seems to be a relatively straightforward question of giving us his opinion based on the facts that are in the record.
that's a fair assessment, Mr. Commissioner.
Okay. So that takes us to number 5.
Correct.
What are you saying here?
Also is the last topic, thankfully. This is talking about the identification and categorization of factors that are proposed as contributing to wet road collisions, which is detailed in the Bogosian legal opinion. So the conclusion that Dr. Flint draws here is that he just doesn't have enough scientific evidence to do the analysis. It's not clear to me what that means, but Mr. Hine intends to build on that point. His point of view is that every accident, whether wet road or not, has its own factors that may have contributed to the accident. And the idea of being able to pinpoint or rank one factor over another in a generality or a vacuum just doesn't work based on his experience. And so to actually draw a conclusion about factors and rank, there needs to be an analysis of each accident. So again, here he's going to be relying on his experience, but he's mentioned to me some previous work that he's done in this area.
Okay, so Mr. Chen, these paragraphs and comparable paragraphs in respect of Mr. Karim appear to throw together several different possible issues. The first and easiest to deal with is the question of whether having identified contributing factors to accidents on the road, again, I say under certain conditions at certain locations, is it possible to rank one as more significant than another or rank them in order? I accept that that's a legitimate question of opinion, and that there appears to be a difference between Mr. Brownlee, who says he's comfortable doing that, and Dr. Flinch, who says in the absence of any scientific explanation, he's not comfortable of doing that, comfortable in doing that. But then there is the more fundamental question about whether it is meaningful to talk in terms of contributory factors in the absence of accident reconstructions. Now, what I'm not sure of is whether that is what you are suggesting Mr. Hine is of the opinion, because there are some significant consequences to that kind of approach. I'm not saying that he couldn't have that opinion, but I want to know first whether that's what the city's expert is proposing.
So Mr. Hine is proposing to speak to why it's not possible to rank them in the absence of an accident reconstruction.
Okay. He's not taking exception to the conclusions of SEMA and the staff that there were contributory factors that were enumerated. Is that correct?
So
just the ranking of the contribution in respect of any particular accident.
So I think Mr. Hine would disagree with being able to immediately identify a set number of factors that could potentially contribute to a collision. You would have to look at the accident itself to say which
That's in respect of any particular accident.
In respect of any particular accident, as I understand the opinion.
So I want to be very clear about this. I've written down that the opinion would be that you can't rank or even identify particular contributory factors in respect of any particular accident in the absence of an accident reconstruction of that accident.
Yeah, I think that's correct. That's correct.
Okay. The question is that may be true, but that's not the approach to traffic safety that has underlain the approach of SEMA and the staff. They have, that may be true in respect of particular accidents, but they have said on a, if you like, more aggregate basis, it is possible to conclude that there were various identified contributory factors in respect of wet weather accidents at particular locations on the expressway. And that analysis provided the basis for the recommendation that went to council. So my question is whether Mr. Hine is challenging that approach.
So Mr. Hine is challenging the approach of when you're looking at a particular accident. I think what SEMA is doing is drawing conclusions about what may be contributing, and in Mr. Hine's view, that's not helpful in terms of determining in a particular accident, what the causes are
But we're not,
and how to rank them.
we're not engaged in this inquiry in determining the cause of any particular accident. We're engaged in assessing, broadest sense, the safety of this highway, but more particularly the approach to safety on this highway of the city through the city's staff in reliance on SEMA's consultancy and their own professional opinion, as we keep being told. And that is that there are various contributory factors, friction, one of them, geometry, another, speed, another, that have contributed to a disproportionate rate of wet weather accidents on this highway. Now, my question is it your understanding that Mr. Hines' testimony, and for that matter, Mr. Kareem's, challenges those basic assumptions, if you like, the basic approach to traffic safety?
So to that, I would say they both challenge the way that, for example, Mr. Brownlee has ranked the factors.
I set aside ranking. If that's all we're talking about, we can pass on to something else. But the words that you have written are susceptible of a much more fundamental allegation.
And just so I understand, it is, I think, the interpretation that you are taking from the from our materials is that it is not possible, even in a general sense, to identify contributing factors to a motor vehicle collision at a curve.
Not to a motor vehicle collision, to motor vehicle collisions as they have been collected in accordance with accident collision statistics.
Okay, so on that point, I think there is likely agreement, at least from Mr. Kareem, as to the potential factors that may contribute to accidents generally. But if we look at a particular accident, then of course they have a much different perspective.
Sure. But again, I say again, I'm not aware that we are looking at any particular accident.
So, when we read the TNS or the Brownlee report, I think one of the inferences that can be made and we want to be alert to is what is being inferred from those factors. And I think it goes towards the point of one drawing a conclusion that we should always assume that it's friction for a particular accident. It's the conclusion that, of course, we want to avoid.
Okay, well, that's fair. I mean, that's a matter of opinion. I just want to know how much further the opinion is going, because at some level, I put it on the table, if there's a more fundamental attack on the way or the approach, let me use that more general term, that SEMA has adopted, and the staff adopted and used as the basis for their recommendations to council, then that might raise issues of concern to those small p participants in the traffic safety analysis of the city from 2013 to 2018, and they might have some, belief that they're entitled to respond to that attack on their professional competence.
No, that's fair enough, Mr. Commissioner.
And I say that would have significant timing and cost consequences to this inquiry that I wonder whether they can be justified. But if the opinion is really down to saying that Mr. Hine doesn't think you can rank contributory factors, then that's a much simpler, straightforward exercise in judgment.
I agree.
Can I proceed on the basis that that's what was intended by number 5?
That is, I think, the majority of it, and I take your point that the inquiry is not about any particular accident, which of course was, it goes back to the third point I made at the opening with respect to the existence of active legal proceedings beyond this inquiry.
Mr. Lewis has joined for a moment.
Yeah, I simply just wanted to observe that neither Dr. Flinch nor Mr. Brownlee were purporting to opine on any particular accident. It was, I think, as
Right.
Commissioner, you said, it's in the aggregate, if that term can be used. There wasn't any intention of suggesting otherwise. Thank you.
Right. I note that it's almost 11:15. I think in the course of this, we have probably, fleshed out all but one of the major issues. I'm in the hands of council as to whether they wish to proceed without a break or take a 10-minute break.
I'm happy to take a quick 10-minute break if that's okay, Mr. Commissioner.
Sure. Okay, then let's adjourn until 25 past 11.
Thank you.
Mr. Chen, why don't you continue?
In our previous discussion on the friction management program, you had raised, what expertise Mr. Hine has in dealing with various municipalities, and I just did a quick look at his resume and just to list a couple for you, and I don't want to belabor that point. It spans from York Municipality, Niagara Falls, Halifax, Calgary, Regina, just to name 5 of them, and he's also been part of this TAC update team in respect of a pavement management guide. So just to emphasize the point that he's a diverse, he's worked with diverse municipalities and can offer a perspective different than a lay witness. And of course, the follow-up of that is that he is unlike a lay witness and has the expertise to opine on that issue.
Okay.
Moving on to Appendix B, there are 2 categories that are left to be discussed, although of course the collision statistics, we had a mini discussion at the start. But 1A of Appendix B, which is the intended use of geometric guidelines. So Mr. Brownlee in his report spends a significant amount of time reviewing the compliance of the Red Hill with the 1985 MTO design guide. And we know he draws various conclusions respecting whether the criteria was met. This section is meant as to provide additional context to kind of understand the analysis a bit better. It's to provide a understanding of the purpose of the guideline, how that guideline is to be interpreted, and what it might mean if a particular criteria is not met. And it's really the latter 2 points, how is it supposed to be interpreted and what it might mean, that will be the focus. As we read it and as Mr. Karim reads it, the Brownlee report appears to treat this topic as somewhat black and white, and that's contrary to Mr. Karim's understanding. Mr. Karim intends to go further though and discuss, as we've set out in our materials, the relationship between the guideline and also the effect of deviation on the general outcomes of roadway safety, because it's important to see what connection, if any, there is between geometric design and safety, and that's related to the last term of reference as to how you look at the different factors that contribute to motor vehicle accidents. So here, Mr. Karim is mainly relying on his expertise on the application of the guidelines, and he will draw, I understand, from various statements from regulatory bodies on the purpose of the guidelines and the safety outcomes.
Sure. Well, this seems to be a matter of opinion, and B seems to be essentially a matter of opinion as well. Is that right?
Yes,
it raises the same question that we spent some time on before the break, but whether Mr. Karim is suggesting that it's not possible to identify contributory factors in the absence of collision reconstruction. I'm not sure whether this is another iteration of the question of simply not being possible to identify the primary cause.
Yeah, I think our previous discussion would also apply in this case.
Okay.
So hopefully we can sidestep that.
What does, just so that I understand this, minimal change, I'm looking down under design speed in B. Minimal changes in design speed will not result in significant changes to highway geometry and associated safety outcomes. What exactly does that mean?
So, as I understand it, I hope I don't do injustice to Mr. Kareem, who is extremely knowledgeable on this topic. The distinction appears to be between the difference of 10 kilometers an hour and 20 kilometers an hour. Because one of the issues or points that Mr. Brownlee raises is that there is a alleged expectancy violation on the Red Hill. Because I think the difference between the design speed and the posted speed is 10 kilometers an hour. And as I understand it, if it was 20 kilometers an hour, then it would be, I think I would put it more expected by motorists. But I think there's an interesting question as to, well, what is the material difference really between 10 and 20 kilometers per hour? And that's the analysis that Mr. Kareem will get into. So it's the minimal changes in design speed and whether that has any impact on the geometry of the highway and also any associated safety outcomes. And I think it's an important analysis because Mr. Brownlee goes on to say that this is an alleged expectancy violation on the Red Hill and contributes to the overrepresentation of wet road collisions. I think that's his conclusion, where he says the interaction between design consistency and motorist expectations, and so on are contributory factors in the overrepresentation.
It may just be that I'm stumbling over the words. I'm not sure what change there is to the highway geometry that we're talking about.
But and I think you're on to exactly what we're on to, and it's that, well, what really is the difference between a 10 and 20 kilometers per hour difference, and can we fairly say that there is this alleged expectancy violation that goes even further and contributes to overrepresentation of wet road collisions? That's the inquiry that we're interested in.
I'm not sure that you understood my problem, but perhaps you don't have to spend more time on it right now. B again would appear to be a matter of opinion. No particular additional evidence that's required. Let's pass to number 2.
Sure. So collision statistics, which of course we had a discussion about earlier. I guess the second aspect of what we're talking about here, just to address the first one. One of Mr. Brownlee's key mandates is to offer an interpretation of certain statistics from the annual citywide collision reports. He draws conclusions based on the data. But Mr. Kareem takes issue with certain of those conclusions, such as his conclusions respecting the resurfacing. So in illustrating why that conclusion is unreliable, Mr. Kareem will provide evidence on standard methodology to interpret collision data and the limitations of drawing conclusions on an incomplete data set. And
so let me just explain what my concern is, because again, the language in this is certainly susceptible of different interpretations. In 2000 and I'll go to 2018 in connection with the lighting study, interestingly, but then also the roadway safety assessment. SEMA drew conclusions based on accident statistics that the city of Hamilton published for the 5 preceding years to the end of 2017, as you're well aware. And the staff adopted those conclusions and that analysis and made recommendations on that basis to the staff, to the council. Now, is there a suggestion that because of the reference in the first sentence to historical collision trends, is the incomplete data set that you're referring to that data set, or is this really limited to saying you can't really draw conclusions about the pre-resurfacing state of the highway from the data that was received post resurfacing?
Yeah, that's correct. It's the latter. Of
It's
course.
the latter?
Yes.
Okay, so that's what number 2 is about?
That is what, well, there are kind of 2 parts to 2. One is the drawing of inferences based on incomplete data set, and then it leads into the second and very critical to Mr. Kareem's analysis is the assessment or examination of the collision statistics between the comparative highways with the Red Hill Valley Parkway, which is what we had discussed earlier, and I would appreciate the opportunity to speak to that pointing.
Okay.
Again, Mr. Commissioner.
Okay, then why don't you do that?
So on this point and in the record, we see references to the Red Hill having high rates of wet weather collisions in various places, and we've seen that statement being relied upon. So, for example, Dr. Flinch in his concluding paragraph makes reference to there being a very high percentage of collisions during wet conditions. And that is troubling to us because it doesn't appear to be substantiated anywhere in the record. Mr. Brownlee makes a similar reference, that there's a much higher proportion of wet road surface conditions that occurred on the Red Hill compared to provincial and city averages. But what this commission has not heard any evidence of that really gets at is whether that statement is true or not. And so we appreciate there have been comparisons, as I just indicated, to the provincial and city averages, but that's a comparison to all roads, right? And we know that because I think Mr. Malone had explained that during his testimony, and that to understand the collision rates that you are seeing and to contextualize them, there has to be an apples to apples comparison. And an apples to apples comparison requires you to take the rates from the Red Hill Valley Parkway and compare it with a peer facility or proxy site, one that has similar characteristics. And to even break it down further by segments. That is the type of analysis that we have not seen and that Mr. Kareem we would like to do so that we can get a precise answer rather than relying on these other statements that just aren't substantiated in our view. So and this approach I think is well accepted. Obviously our Mr. Kareem, who has vast experience on this front, has told us that, but Mr. Malone has confirmed that. The idea of overrepresentation is also discussed in Mr. Brownlee's report, and he talks about comparison to peer facilities, so similar ones. And that is just not done. So for anyone to accept that the Red Hill has a high rate, it might very well be the case, but that analysis just needs to be done so that we can be sure about that. It's relied upon in Dr. Flinch as part of his analysis of all the factors. And if we look at his conclusion, it's the first one that he raises. And that again is troubling to us. Where does he get that from?
Let me just back up for a second. So are we talking about wet weather accidents now rather than collision rates generally?
Yeah, my point here is on wet weather accidents, but of course the intention is for Mr. Cream to do a comparison of both.
And all collisions or just serious collisions as defined by?
I understand it's all collisions.
So let me just understand. First of all, what are you referring to in Mr. Brownlee's? Specifically, what are you referring to in Mr. Brownlee's?
So if I can take you to it's paragraph, page 27 of his report.
Page 27.
Footnote 58.
Footnote 50. Sorry, footnote what?
58, where he says road safety term.
Yeah.
Used to describe an in-order frequency of specific collision attribute when compared to paratransportation facilities.
No. What is it that you object to in? You say he assumes that there's a disproportionate wet weather accident experience without evidence. What are you?
No. He's simply referring to the SEMA reports.
Yeah.
Page 23. That's at
Right.
4.1. Yeah.
Well, yeah. So he refers to the SEMA report.
Yep. I found there is it's the third.
City refers to the SEMA report, relied on the SEMA report. They essentially rely on the 2017 annual collision report, among other things. Is the view here that they were all wrong? That there was no, I mean, are you challenging what the city has done for the last 5 years?
I think it's a bit more nuanced than that, and what we intend to do is provide more precision.
No, I'm not going there. We've got wet weather collision rates that form the basis of everyone's approach. Now, are you taking the position that, is the city now taking the position that its own staff was all wrong, both in terms of the actual experience on the highway and with respect to the appropriate comparators?
The purpose of the exercise.
No, I'm asking is that I understand what the purpose is, but the implication is what I'm asking about.
The answer to that question is no, to be direct. But it's
how can it
a no with an asterisk?
But how can it be no when the city's already, to take one issue here, the city's already identified what it regarded as appropriate comparators. SEMA had some, and then you recall Mr. Soldo said, I want to add another one. Now you're saying, no, those aren't appropriate comparators. You want a complete analysis done of other comparators that you think are more appropriate.
Well, I think the city's consultant provided that analysis, and again, you know.
No, Mr. Saldo added one, and the city and the city's consultant provided that.
So sorry, I missed that. I missed that point.
I said I think Mr. Saldo, when he came on board, asked for an analysis of another highway, and the city provided that in the latest collision report.
Right, and
So,
as I recall, that analysis was not done by segment. There's, based on our discussions with the experts, a more refined way to do the analysis, a more comprehensive analysis to assess whether there is a high degree or not of collisions. I'm not disputing that there are other ways, but we're in this context where there's a lot, I think, that goes to this point, and we now are at the expert phase. Our expert and others have proposed a method that's more refined, more precise, and I think there's value in that evidence being given, at least looked at, to the commission. And again, it does, and we had this discussion at the start, tie back to the term of reference, because it plays into the I'm going to call it the factorial analysis. It's not just friction; it's what the rates of collisions are. And here we're talking about wet road collisions, and we have a pathway forward to get more precise evidence to assist in answering the terms of reference.
Mr. Chen, here's my problem. If the city wants this evidence, it seems to me that it requires a very extensive review and considerable judgment as to which highways and which segments of those highways are appropriate comparators. If this is, I would say that this in the first instance is well beyond what I would have thought was appropriate at this stage, because we've had 3.5 years of this inquiry, and we've had plenty of evidence as to how the city proceeded, how the city's consultant proceeded, how the city proceeded, what they regarded as comparators, what they regarded as the appropriate analysis. You're coming in and saying, well, that really wasn't good enough, because for future litigation purposes, what you want is a much better finding that says there never was a problem here in the first place. I get all that, and it may be that analysis is appropriate, but not on the very selective basis that a particular expert of the city provides. If there is such an analysis to be undertaken, I think we need a proposal from the city that involves a much more independent approach to looking at this. And I say this for a couple of reasons. One is, it is inevitable, as I'm sure you know from your many years of experience, that experts provide the evidence that their clients want. And this just carries with it serious concern for selective provision of evidence. And then the question becomes, well, how do the parties whose reputations are challenged in one way or another by this approach respond? And that's really not the most efficient way of dealing with this. It has significant time consequences and cost consequences, and I'm not sure that at the end of the day it really develops the evidence the way anyone would want it to be. It's much more confrontational. If the city believes this is necessary with the timing and cost consequences that entails, then I think the city should propose something of a much more independent nature on this issue.
So my first response, Mr. Commissioner, is that it seems to me that Mr. Kareem's objectiveness is being challenged when there really is no evidence for us to conclude that there is an issue with his
Right.
impartiality, and he's independent, and I appreciate that he's retained by the city, but he is not just looking at one a highway. That's a DVP. He's also requested a variety of other data for a variety of other highways from the MTO, which he hasn't yet received, and he's undertaking an analysis that I think is well accepted in the industry. So, and of course, the inquiry process has built into it certain mechanisms to explore impartiality through cross-examination. See Mr. Lewis conduct a number of quality cross-examinations. I just want to make sure we're being fair to Mr. Kareem, that we're not unintentionally sending any messages with respect to his skill and
I am not sending any message.
Yeah, he would be highly concerned about that, having not even done
that at all. But I will be a little bit more specific. This is as much a matter of judgment as it is of technical expertise. Choosing which highways and which segments are apples to apples, bearing in mind that there never can be, as the evidence demonstrates, real apples to apples. So that judgment has already been made by SEMA and by the city staff. And for litigation reasons, the city apparently now wants to have that reassessed. And if that's what the city wants, it's entitled to have that, I think. But in a process in which I think it's fair both to Mr. Kareem, but also to SEMA and the city staff, who have already taken a position on these issues. So that seems to me to require some kind of more entirely independent joint instruction with some process that involves a joint assessment of which road segments and which roads and which road segments are going to be analyzed.
And I'll just couple of the first point is that, of course, Mr. Kareem's analysis will detail why he thinks a particular highway is a apples to apples comparison, and certainly Mr. Brownlee, who has expertise, can tell us whether it's a citrus fruit or not. And this analysis isn't focused on the outside litigation. Of course, it may have an effect, as I indicated at the start, but
no. But I think you made it very clear that that's the context in which you are concerned about that. So
that is part of it. But I want to be clear that we think this goes directly to the terms of reference. It is certainly not solely for the purpose of litigation, but it's been raised square and center in this inquiry. And again, it goes to the terms of reference, which we've discussed. And this analysis is what will provide we say will provide a more refined analysis. So I hope I've clarified that point. And if the proposal is a joint one, the city thinks that there is value to undertaking this analysis, and I will say something is better than nothing, but Mr. Kareem has started the analysis, knowing that it will take some.
I'm aware of that, but I'm sure he'd be happy to turn over what he's received from the MTO thus far, if that's what's necessary.
And frankly, as I said, he's still waiting for MTO to provide him with
So I understand.
additional data.
Okay, anything else?
I think that takes us to the end, as we've addressed the wet road collisions point. So that concludes my submission, Mr. Commissioner.
Yeah, the wet road. Okay.
I can belabor you with one of those fancy lawyer closings that sum up everything, but I will refrain from doing that.
Okay, thank you.
Yeah.
Sparing us both, Mr. Chair. All right. I think Ms. McIver's on the call as well. Do you have anything you want to submit at this stage?
Thank you, Mr. Commissioner. I just wanted to confirm that our position remains as we've previously stated, in terms of it not being necessary to explore on specific Ontario roadways and make findings about the reliability or the safety of these roadways in order to decide the terms of reference. And so whether that's done in a comparative manner or not, it is and remains our view that that is simply not necessary in the context of this inquiry. And then I'll also note, I know it's been discussed today, MTO witnesses have testified at length during this inquiry, to the extent that the participants are now suggesting that additional factual information about MTO roadways be canvassed at the inquiry. We suggest that's inappropriate. It would lead to inefficiencies, I would say, in terms of potentially giving MTO employees the chance to get their views across on the roadways in question, the suitability of the comparisons and whatnot, when really it's in our view outside the parameters of the true issues that need to be decided in this inquiry. So our view remains, as set out previously, and we would we take the view that additional information about specific provincial highways is just not necessary.
Can I ask whether that comment means you have a problem with some kind of broader assessment of the accident experience on MTO highways that are regarded as comparators with the Red Hill Valley Parkway?
We do, in that we just don't feel that it is necessary to go there and get those statistics. And I guess the bigger issue is, there can be an analysis of Ontario highways and statistics and collision rates But to make any findings then about the Red Hill Valley Parkway, there needs to be an opinion about what those statistics mean on the provincial in the provincial context. So my friends appear to be anticipating evidence showing that the collision rates at the Red Hill Valley Parkway are lower than certain Ontario highways, and therefore the road is safe. But you know, in order to make that finding, you have to do an assessment of what the collision rates and statistics on the Ontario highways mean. And that we just haven't been given an opportunity to call factual evidence about that. And to the extent that at this stage we're going to sort of explore those these new sort of areas, you know, we would just, you know, urge a finding that's in keeping with efficiency and cost and proportionality. In our view, respectfully, we submit that it's not necessary to go that route at this juncture.
So neither necessary nor proportional.
That's correct, yes.
Okay. I'll let Mr. Chen speak to that if he wants to.
A couple of points, but I thank Mr. McIver for highlighting the need for expert evidence on this issue. I agree it is complicated, and we have a qualified expert to undertake that analysis, and they have the data, or they're going to get the data from the MTO, I presume, to do that analysis. I think Mr. McIver doesn't speak to how to properly conduct, you know, an assessment of whether there is an overrepresentation. I appreciate that it will obviously involve comparisons of you know, the DVP in certain 400 highways. I think though there are ways to kind of sidestep what the inferences that Ms. McIver may be concerned about in just in terms of how we describe the findings, and that we can obviously work with. But you know, this inquiry has been structured as, you know, phase 1, phase 2, with the fact witnesses going first, and the MTO witnesses that testified, as I recall, were all, you know, friction specific. Would we, you know, pose questions about collision statistics on, you know, on a particular highway? That just doesn't seem like a fruitful exercise. And so, you know, what we did, of course, is leave that to the experts. And just the point about whether it's necessary, I think I've dealt with that. It goes to you know, one of the factors that Dr. Flint relies on to draw his conclusions. It's the wet road, the high wet road collisions point, is again cited elsewhere, and this is the analysis that will get to whether that's true or not. So it's on that front, it's both reasonable and necessary. So, you know, Ms. McIver will cross-examine the expert, and it appears that she has potentially the most ammunition in doing so. So I don't think that would come at a great cost to her. Of course, I suppose there's the option of putting in a responding report, but not sure that's necessary.
I think what this has identified is that apart from, I gather, province-wide statistics, which we've seen referred to, there are no statistics on a highway by highway basis, much less on a segment by segment basis. Is that correct, Ms. McIver? No public statistics anyway.
Sorry, in terms of whether those statistics exist
Yes.
for provincial highways?
Yes.
I'm actually not certain about that. I haven't seen any to date.
But it may be a question that, as part of this process, whoever is conducting this analysis will be generating statistics for the MTO highways as well, in order to have a comparator or comparators with the Red Hill Valley Parkway, and it's that you object to.
That's correct, Mr. Commissioner. I'm not sure what data specifically has been requested, and I'm not sure what data will be provided. But from what Mr. Chen has provided us in terms of analysis, it does seem to be focused on a comparison between some specific Ontario highways versus the Red Hill Valley Parkway. And I fail to see how that falls within the scope of the terms of reference. And it could be that some findings in the other expert reports, are also outside of scope. I just don't see, how getting into those sorts of details and weeds are necessary to answer the questions posed in the terms of reference.
I'm proceeding, although I confess I haven't looked at this point specifically, that insofar as comparisons were made, they were made with respect to publicly available statistics relating to MTO highways.
I believe that is the case, or based on the record that's before you already in terms of findings that have been established to date, the reports that are in the record.
I was thinking about those reports that made comparisons. They presumably were made with respect to or on the basis of publicly available statistics. But what you're concerned with is that what Mr. Chen is proposing his expert do might involve generation of statistics that have not yet been developed, are not public, and by implication raise issues with respect to the safety of MTO highways, which you say are beyond the issues in the terms of reference. Is that an accurate way of describing your concern?
That is correct, Mr. Commissioner, yes.
And if I just very quickly respond to that,
Go ahead.
There's no creation of the statistics. It is so just to be blunt, Mr. Kareem's team has put in an FOI request a while ago to obtain the data, and I don't believe there should be any obstacles to obtaining the set of data that they'll need. And as I understand it, it's a routine exercise for them to do so, and there's no restrictions subject to timing, of course, which we could use some assistance with.
You're saying there should be no restrictions on them performing whatever analysis they want on the data that's released by the MTO.
Yeah, that's correct, and it's not confidential by any means.
Okay. Okay. If no one else has anything further to say, let me just review where we are, because I think it's very important that we move forward on this as much as we can, as quickly as possible. So there are certain matters that I think are clearly within the scope of what's contemplated for this phase. And I'm thinking in particular of the matters, first of all, that Dr. Baj is proposed to report on. And I would say again, on the basis that the extent of any evidence that Dr. Baj is introducing beyond what's already in the record, that would be limited to evidence that is his scientific basis for the conclusions that he reaches in his report. With respect then to Mr. Hine, the same principle would apply with respect to 1A, B, and C.
Right.
As opinion evidence plus any evidence in addition limited to the scientific basis for his conclusions. I'm going to reserve on E. I'm going to reserve on 2.
Did we skip D?
Well, on this enumeration, it appears we have. D, I think, is in the same category as A,
Okay.
B, C, and
Okay.
A, B, and C.
Okay.
Opinion evidence. And supplemented only by any scientific evidence that he might have to support his conclusions or opinion. So pass on E, pass on 2. Number 3, what I want to do on 3 is reserve pending a discussion between Mr. Chen and Ms. Roberts to see whether you can't come to some kind of conclusion as to, well, I'll put it positively, whether Dr. Baj is in fact covering all the ground that is proposed in number 3, or alternatively, Mr. Chen, defining a little bit more clearly what Mr. Hein would opine on, given what we have now had by way of a much more expansive description of what Dr. Baj will be doing and any discussion you've had with Ms. Roberts. Okay?
Understood.
Sorry, Mr. Chen?
Oh, I said understood.
Okay, thank you. Number 4, I understand basically to be opinion evidence, and that's fine. If there is anything scientific that supports his conclusion, fine, or technical. Number 5, going to pass on is that complex of issues that we will. I'm now passing to Mr. Kareem. 1A, 1B, 1C, I think is in the category of opinion evidence. I don't think it relies on anything more other than if there are industry statements upon which Mr. Kareem relies that support his position, that can be included. Number 2, collision statistics is part of the discussion we just had, and I'm reserving on that. Number 3 is in the same category. Okay, we will get you a decision with respect to the matters on which we reserved, apart from, be specific about the number. Number 3 under Mr. Hines, Appendix A, for which we await further communication from Mr. Chen and Ms. Roberts, or collectively, or Mr. Chen.
We will do that.
Okay,
Thank you, Mr. Commissioner.
thank you. We'll stand adjourned. If there's nothing further that we have to deal with today.
I believe so.
Okay, thank you very much.
Thank you.
Thank you.